Hello everybody, Shana here with CA Bar Style. I hope you are doing well. Today's topic is Attorney Applicants and the California Bar Exam. This topic was a request from one of my followers. Thank you for being patient while I got this together. So I'm going to discuss some factors that go into the attorney exam and things that attorney applicants should consider and should be aware of when preparing. I hope this is helpful. And one thing I'll say is this applies to attorney applicants in the United States that have been having an active license for at least 4 years, and make sure that you get, of course, approval from the California State Bar before thinking about applying for the attorney bar, depending on when you plan on taking it, February or July. So let's get to it. All right, number one. If you are an attorney applicant, I want you to first consider how long has it been since I've taken an exam, particularly a bar exam. So if you have been out of the bar exam taking game, maybe got licensed 20 years ago, which happens, 15 years. People come here after 15, 20 years of practice and want to take the California bar. You want to give yourself ample time to prepare. So please do not come here after maybe 5+ years of practice and just take a 2-month commercial bar review. It's going to be really hard to prepare that way, and I'll cover some bases as to why in a moment. But giving yourself adequate, realistic time to prepare, taking into consideration whatever else you have on your plate, is really important. And I think it's a pitfall that a lot of attorneys fall into, coming here and just preparing in a couple months after not having taken an exam for a long time and getting acclimated with the black letter law again. Remember, there are 15 subjects of law to know. You are required as an attorney applicant to only take a 1-day bar. That is 5 essays and a performance test. And those essays have topics that are extremely repetitive, but a lot of the commercial bar review, and this is my second point, the type of bar prep you go into, right, is very important, because a lot of those commercial bar review courses that may have worked in New York or Florida or Texas or wherever other jurisdiction you're coming from, they don't work for a lot of applicants in California. So a lot of applicants come here, attorneys come here very frustrated, taking the exam 2, 3, 4 times after going to Barbary, Kaplan, Themis, and I'm not knocking those courses. I have my thoughts on them, and I've talked about it over the years in these videos. But for purposes of today, those courses work for some applicants. For attorney applicants, they don't work very well, especially for applicants that have not taken the test in a long time, whether it be the California bar or another bar, and have not been acclimated or have not been refreshed, on the areas of law that are tested. So the type of bar review is very important. You want to make sure that you're not just buying commercial bar review materials or materials off Amazon. A lot of the commercial outlines contain a lot of nuances of law that are not tested on the essay portion. They only come up on the multiple choice. So a lot of attorneys fall into this kind of pattern of learning the law, maybe giving yourself enough time to learn the law, but focusing on law maybe because you just don't know. You don't have that coach like myself guiding you to say, this area in this outline does not come up on the essays here. It hasn't come up really ever, or in 20+ years. There are patterns of what is tested. And so you're spending too much time on black letter law, and that can really waste time and eat at your study time. So again, just to kind of go over, how long has it been since you have taken a bar exam in particular? Even if it was the California bar, whatever bar you are going for, if you're, let's say, a repeater of the exam, and if it's been more than 5 years since you have taken an exam, a bar exam, you want to give yourself at least 8 to 10 months of study time. And that includes the 2 months before the test, okay? So every situation is different, but in my experience, applicants that have waited, or it has been a while since they have seen law and they've been really practicing only in one area of law, let's say as an attorney, you want to give yourself enough time, first and foremost, to learn the law again, refresh the law, and then don't forget, we have areas of law that have distinctions, like evidence. You have to know the California Evidence Code. You have to know California Civil Procedure, and professional responsibility California distinctions, as well as California specific subjects of remedies, agency, partnership, corporations, wills and trusts, community property, and, as I said, professional responsibility distinctions. So cannot stress enough to give yourself enough time to really connect with that law and not waste time on nuances that are not tested. So number 2, the type of bar review is important. Don't rush it. Don't cram. It is not attainable to cram for the test. It's almost like this unreasonable kind of momentum that is around how to prepare for this exam, where applicants come here and think, oh, I can study for 2-3 months. I've been practicing for all these years. I know how to take a test. It's just not the same. California is different. And how are they different? Well, number 3, the writing component. So when we're talking about the law as the first step, that is only the first step. After that, we have the writing component. And when we're talking about the essays, the 5 essays, well, we don't know exactly what topics are going to be tested. So there are 15 or so areas of law. Professional responsibility is always tested, but it can be a crossover. It tends to come up with criminal law or corporations a lot, and trusts. It really comes up with many different areas of law. But regardless, there are other 4.5 essays where we have to be ready for any potential subject. And when I mean subject, I'm not just talking about torts. I'm talking about the subcategories within the subject. So when a lot of applicants, attorneys, I'm saying applicants, but right now I'm referencing attorney applicants, take the California bar, actually to back it up in their prep, in those commercial programs or an type program, you're learning the law, a lot of law, and then you're going into very little strategy. And that is really a very big missing component, because strategy involves, okay, we have torts. Well, what are the 15, 20 categories of torts that come up on the essays? And then within each category, there's maybe 4 or 5 different ways those essays are tested. So negligence, as a great example, can be tested as a straight negligence essay, as multiple defendants being potentially liable for negligence, vicarious liability issues coming up. So there are a lot of different negligence type essays. You also have negligence coming up with other areas of torts or an agency crossover as well. So you have to have strategy after learning that law before you even get into your practice. And a lot of attorney applicants, by the time I'm working with them, do not have any strategy at all. And it's very, very frustrating because, again, they've been practicing for a number of years. Now you're coming to California, and California's going, that's not how I want it. And if you've ever found yourself taking the test here, and you get, let's say, a 55 or 60 on an essay, which is not passing, you need a 65 or higher, and let's say negligence is tested and you're like, I know the elements of negligence. How could I have gotten a 55 on this? Well, perhaps you missed a key vicarious liability issue, or you missed the defenses, which is missed a lot, because even though you learned the law, it wasn't in your strategy on what a given fact pattern or call of question for the essays was going to require you to present. So that's a big step. There's also formatting on the essays, timing, analytical posture, counter arguments, crossover topics. So there is a lot there. It's heavy. It's not just learning law and doing some practice, which again goes back to the type of bar review that you are doing. Many bar reviews do not cover strategy. And that third step, which is doing enough practice so that by the time you get to the test, you've seen a variation of the essay that is in front of you, you've practiced on it, you connected with any issues missed, and you have a pretty good idea of how to answer the asked calls of question. Now, another big factor is the amount of feedback that is needed. Now, attorneys, a lot of them, and that's going to be factor number 4, which is, are you working or not? But when we're talking about the writing component and the standard of it, it is really important that you have clarity as to what the structure of an IRAC looks like here and how to carry out the practice, and making sure that you have that final step, which is the individual feedback that in my course comes from only me. I am the only tutor, and I work very closely. I get some very busy attorneys across the country. I have firms referencing me, referring me, their attorneys all the time, and we have to develop skills or refresh skills that have not been utilized in a long time in practice. And it is doable. Another factor is memorization. I know I'm 42 years old now. I don't have as sharp as mind as I did, well, a pretty sharp mind, but not as sharp as I did in my 20s in law school for all that memorization. And I work with attorneys. I recently helped pass a daughter years ago, and her father came to me about 2 or 3, it was pre-COVID, so about 4 summers ago, and I helped him pass. But he had been a practicing attorney 25 plus years, and he had a really hard time with, how am I going to sit for this long, and how am I going to memorize all this content? And of course, working with him and helping him build that confidence, he was able to do it, and he did pass on his first time working with me. So it is attainable, but again, you've got to make sure that you're not just going into a commercial bar review. For most applicants, you're factoring in how much time it's been since you've taken the last test, giving yourself enough time to prepare, and you learn not just law, but also how the law is tested. You have strategy going in, and you do an abundance of practice. It always amazes me when attorney applicants come to me and will say, I only did a couple of PTs, performance tests, or I only did a couple of essays in a certain area of law. You've got to do a lot. And so I usually recommend at least 10 to 15 or more issue spot per subject of essays. And we can get into that more if you're in my program of exactly how to carry that out. Okay, so another factor is number 4, as I said, are you working? Attorneys, a lot of them are working, running busy law firms, working for busy law firms. Some take off, but if you are in the category of working attorney applicant, you want to take that into consideration as to whether you're going to have enough time to prepare. In the early months, and when I say early months, I'm talking about months, 2 months, everything aside from the 2 months before the exam, you want to have about 10, 15 hours of study time in the schedules that I make. The 2 months before the bar, I'd say about 25 to 30 hours a week of study time. So you can still do that with a part-time or not too heavy of a workload or caseload, but with a heavy trial schedule, like I've seen some attorneys try and do, or a really heavy transactional schedule, it's going to be hard. So make sure that goes in kind of with factor 1, which how long has it been since you've taken the test, to kind of assess how much time you're going to need to prepare. And then also as a factor, are you going to be working? I mean, also, do you have a family? A lot of attorney applicants have kids. So how are you going to balance all of that while studying for the exam? The good thing is you only have the essays and the PT. And I say only because it really does take a lot of stress off not to have those 200 multiple choice. I know that can be frustrating to hear from attorney applicants that have taken this test over and over again, but you've likely either been trying to do it on your own or going to a preparation that is just not jiving or connecting with you. So it's time to change up that strategy, and you can get this done. The last component that I want you to keep in mind is that the way the law is tested is not the same always in California as the way you've been practicing. And this is a frustrating point for a lot of attorneys because they come here and they're like, I don't understand. I've been practicing in this area for 20 plus years, and this is not how we practice. This is not how I would argue this in the real world. It's almost like you have to accept the way they tested here as true and just surrender to almost what you know, which can be a very hard pill to swallow for a lot of attorneys that really feel like I know this area, I've practiced in it, and what I'm relaying is the truth. It's the reality of it, but then they get a low score because California's going, that's not how we want it here on the bar exam, maybe in practice. But on the bar exam, the formatting, the presentation, the analysis is different. And that goes on the performance test as well. The performance test, I would say, is probably the hardest area for attorney applicants, ironically. They have a really hard time with it. The 90 minutes is crucial, but it's also hard to do. We don't really, as practicing attorneys, spend 90 minutes whipping something up. We want to take our time, make sure we're presenting something organized. And there is a way to do it where it looks lawyerly. The standard is still pretty high, but you have to know what you're doing. And so it's not just practicing them. Again, there's got to be that strategy. And you can watch other videos that I have on how to attack the PT, what my theory and ideology and approach is to the essays. For purposes of this video, I'm just kind of giving a highlight of things to look at. But my point is, the way that we practice, and I am a litigator, I practice a little bit, not too much anymore, is very different from how you present the requisite legal issues on the California bar exam. And so it does take some rewiring, retraining, and almost digressing from the experience that you're bringing into the bar world. And that is definitely a key component. So I hope that gives you some insight. I am available for consults. I'm available to talk to you and tell you, if your plan looks realistic, what I would maybe modify, how I can help you. Feel free to email me at cabarstyle@yahoo.com. I hope that the state bar does eventually grant reciprocity to attorneys that have been practicing for a certain number of years, because I think that to come here and have to take the bar after 25 years of practicing is kind of silly, and I think they are evaluating that right now, the California State Bar. So I do hope eventually they grant that reciprocity. But in the meantime, the attorney exam is still necessary, and keep those factors that I mentioned before into consideration. Again, I'm here if you ever need to discuss or have questions. Good luck.